do a lot of these debates, so I usually don't talk about them. It went okay. It's on YouTube. You can watch it. I'll let you guys be the judge. One of the weird parts is I was at UT yesterday in Austin at the law school, and I always see familiar faces. I'm like, wait a minute. You were in my class last year, weren't you? Whenever I go to other schools, I see my former students in the road. And it's kind of strange because they transfer after 1L. And they go to UT, they go to Baylor, they go to SMU, they go to UH. I always see my students like, what are you doing here, right? You're not supposed to be here. But it's, it's kind of nice to get to see them in a different element. But I'm doing the exact same debate tomorrow at Cornell. I get around pretty far. I think it went well. Okay. Any other questions? Yes, sir.
Was it really only 3 cases?
Yeah. I'll mention that in the past, I actually combined the current class to the next class. So the current class, we do Meyer, Pierce, and then Buck v. Bell. And our class for Thursday, we did Caroline Products and the Optical. I used to actually make those a single class, and I divided them because it was too rushed. I was able to do that because we made First Amendment required. So I basically dropped First Amendment coverage from 1L ConLaw, and I basically spread some things. I didn't actually add anything. I just spread stuff out. So the reading today might seem light, but will be a lot of time on the third case, I think. Yes, that was it. Okay, good. This thing's working now. All right, yeah. Occasionally it's not on, and I have to call them, and they turn it on. You ever notice those phones in the hallway, what they're there for? That's what I use them for, to remind us to turn the projector on. Okay, so please sign in for attendance if you haven't already. And I want to start off with a poll question that will get you thinking. And I know people are going to complain of how I phrase this question, but I try every year to phrase it better and better. Okay. All right, so this is your question. And I'm not going to call on people. If you want to raise your hand, you can. But I'm not going to cold call on this question. So the question's this. Which is a greater deprivation of liberty without due process of law? Compulsory sterilization for imbeciles, that is the sort of law at issue in Buck v. Bell, or lifetime commitment in sex-segregated prisons. And I want to just explain these two choices. In the second choice, you are locked up for life in people of only the same sex, and you're not able to reproduce. You can't, right? You're not able to. In option A, you're sterilized, released, but you also can't reproduce. But you're free to go about, live your life, get married, do whatever you want. All right? Again, I'm not going to cold call, but we'll discuss it for a little bit. All right, so put down your answers, and we'll see where we get with that. Maybe another 10 seconds or so.
Question?
Don't fight the hypo. You can ask a question in a minute. Okay. I've framed this question maybe 5 or 6 ways over the years. I've never quite gotten exactly what I wanted. This is one of the better framings I have. Okay. I used to frame this question about which would you prefer. I don't do that one anymore. Another year, I contrasted an option of compulsory sterilization or being sent to war to die, the military draft. I settled on this one because it's perhaps a little bit more feasible, but key to the case. All right, let's see. Let's see what the results are here. That's pretty damn close. That's just about right down the middle. Huh. All right, now, Sorch, now you can ask your question.
Well, my question was going to be if my answer would have been contingent on the response is the life term commitment, their conjugal visits and that? Or?
No conjugal visits, my friend. Sorry, you are stuck. You're by yourself. None. I guess it's a reasonable question. I should anticipate that, but this is why writing a question is really hard. People always try and fight it. Now, these results are right down the middle. That's usually about where I get in when I put this question up in various forms. And I think it illustrates an aspect of Buck that people don't quite think about. Even today, we incarcerate people. We lock people up for the rest of their lives for various crimes in which they, maybe absent conjugal visits, don't have the opportunity to reproduce. I mean, things happen, but as a general matter, they are not having children. And some of these offenses aren't particularly violent, and maybe they're not that serious, right? But we accept the fact that we can lock someone up for their entire life for a non-murder offense, for some I'll give you an example. Child pornography. Not actually physically abusing a child themselves, but possessing child pornography. Depending how many photographs and videos you have, you may get 30, 40 years in prison. And if you're a person in their 30s or 40s, that's basically a life sentence. You'll be in there to your 80s. Well past the age of reproduction at a minimum, right? But the alternate option that we saw in Buck v. Bell was to simply sterilize the person and let them go so they're no longer a threat to others. Now, I can change this hypo a little bit more. And let's say there's a person who's convicted of rape, a heinous crime, and they're given an option spending life in prison, or they can be released early if they agree to a sterilization and castration. Is that feasible, right? Would a person be willing to spend the rest of their life in prison versus being released earlier at their own choice and having castration performed? What if it's not a choice, right? What if the actual sentence by the court is X years in prison, and then upon your release, castration and sterilization? Again, I'm not going to cold call people. If you want to raise your hand, I encourage you. But these are the sorts of issues to think about when we get to the second half of our class, which is sort of this personal liberty discussion. Right? We're not talking about, can South Dakota, withhold highway funds for, underage drinking, which is, I find important, but isn't philosophically difficult, right? These are very key choices that go to the center of who people are and how they exist in our society, right? And I think even just with you 35 of you who voted, 34 of you voted, it's right down the center, right down the middle. Almost, this is about as close as it gets to 50-50. Anyone want to add anything? I don't want to cold call on this question. I think it's a little personal, but want to add anything? Yes.
I guess with B comes like multiple liberties that you're deprived of, whereas A, you can see that it's like in my perspective, it's like one liberty versus multiple liberties.
So I think what you're getting at is when you are choosing option A, door number 1, you lose a liberty of reproducing, of having a family, right? For example, or at least a biological family you can adopt, I suppose. But with option B, you are going to lose out on all other facets of your life through incarceration, right? I mean, you don't think about it. When you're in jail, if a loved one is sick, you don't get to see them when they die. Your children grow up, you don't get to see them. You lose out on so much. So you're saying that the option A would be less burdensome than option B on your freedoms. Anyone else? Yeah, no one.
I'm with, I agree. Like, I had the same thought. The first question when I read it was, well, which one is the greater liberty, right? The liberty to reproduce,
can be under control, but if you're getting a lifetime commitment in a prison, you probably did something to get yourself in that situation in the first place.
Oh. Well, let me ask you a follow-up then, if I may. In 1920, when Buck was decided, it was a crime to be an imbecile. And the society agreed that that was a worthwhile crime to incarcerate people. Was Holmes wrong, right? If the state had the power to lock someone up for life, which they admittedly do, why couldn't they choose a less burdensome punishment for Carrie Buck? At least half of you in this room think that the option A is less burdensome. At least half of you. And why can't the state put people to that choice? Yeah.
I guess I agree with Ruben. He said it. I couldn't find a nice way to say that, but like imbecile to me in my head,
Yeah.
I related it to ignorance. And if you're ignorant, there's steps you can take and be proactive to get rid of the ignorance. Why wouldn't you want to educate yourself? So that's, to me in my head, that was laziness on the imbecile side.
Very well. We'll talk about what it means to be an imbecile. It's not what you think it is. In this case, it was a label that was used to basically describe someone society didn't like. It had nothing to do with their IQ. It had nothing to do with their intelligence. In fact, Carrie Buck was literate. She could read. She could write. Yeah, Fosa?
I think there's more than one liberty that's be taken away from sterilization. Because if we think about in present times, mothers who can't reproduce,
Yes.
like mentally, they will never know what it means to care for a child. I think that's one of the liberties to bring them to school. The emotional aspect of it, how they be able to function because of that, that type of feeling. I think there's more at stake.
Mm-hmm.
No, I'm not a father, but I'm pretty sure anyone who's a parent here, no longer have their child or can't have a child if they probably have a
I mean, to this day, we do, if there's parents who are deemed incapable, the state removes their children from them. That happens on a daily basis around the world. If a parent is deemed unfit to be a parent, the state steps in and removes the parent, puts them in foster care or whatever, or custody. Yeah.
My only argument for that would be that if you do have like this desire to care for a child, like adoption still exists.
It does.
So
There are lots of people who just aren't fertile and they can't reproduce on their own, and there's nothing wrong with that. They try, it doesn't work. Adoption exists. So I want to come back to this question, right? It's very easy to dunk on Justice Holmes, and I love dunking on Justice Holmes. I don't think highly of the guy. Well, I think highly of him, but I don't like his opinions very much. But I want you to think very carefully. If we accept that the state can do B, because the state does B every single day. There are people in prisons around the country who are locked in, sex segregated, they cannot reproduce, right? If we accept that they can do B, should A be an option, right? And if A can be an option, is it that much worse? And I want to throw one more cog in that fire, which is the military draft, right? We, at least most of us, probably acknowledge that if there's a war, the state can draft people to basically go to the front lines and be potentially killed, injured, maimed, wounded, right? Now all of our wars are fought by drones, so I don't think it's something to worry about anymore. Kids with joysticks now will be fighting the wars, but back in the early 1900s, we were in the midst of World War I, right? Where young men, 17, 16 years old, were being sent to the front lines in Europe, tear gas, blowtorch, tank fire. I mean, the most awful ways of dying. What I'm getting at is this. If the state has the greater power to send you to your death, to incarcerate you, lock you up for life in a sex-segregated prison, should the state have the lesser power to remedy what ails you? Now, again, the idea of this imbecility is garbage. I want to actually move beyond that. I want to focus on the more difficult issue about what sorts of deprivations of liberty are warranted. right? We don't talk about the Eighth Amendment in this class. One of the criticisms I got, I don't do death penalty cases in my 100 cases book, right? But if we can lock someone up for life, if we give them the choice of lashes, some countries do that. Instead of being in prison for a decade, they'll give you X lashes, where they take basically a whip and they whip you. Which would you prefer, being locked up for a decade or having excruciating pain from these lashes? Don't be so quick before you give an answer, right? Our society says, no, we cannot inflict corporal punishment. Instead, we incarcerate. You know, is the lashes a greater, probably a lesser intrusion than the sterilization, because lashes heal, right? Eventually scars will bleeding stops, but reproductive capacity doesn't return. All right, anyone else? I like. This is why I know when I split the class in half, because this discussion usually takes its own time. I don't like to rush it. Anyone else want to add anything? All right, just think about this. You'll probably think more about it after class, I'm sure, and ponder when you can't fall asleep tonight. By the way, the Yankees are out, so I'm with the Astros now. It's fine. I've more or less become it's. You must have been absent last class. Yeah, I've more or less become a Houston fan unless the Yankees are playing. So now I'm okay. We'll see what happens. Okay. All right. Anything else? Yeah, Nolan.
I guess, I mean, for the hypo, is it only for imbeciles, or can these punishments, because, I mean, in my mind, I'm just thinking that, like, I think there's times where someone should be punished more than just sterilization for the crime they committed. Say for like child pornography, not only having it, but if you participate in it, does sterilization really prevent him from what he's doing? So like,
it doesn't, and that's I don't want to go down that rabbit hole, but there are some governments who try to propose sterilization for those who engage in certain sex offenses. It doesn't actually work. It's power. It's not just sex. So the abuse doesn't go away when your stuff's snipped. Anyway, but I just raise that as like a hypothetical. Yeah, I think there was a case, was it in Georgia or Alabama? I'm blanking on the state where, yes, thank you. Yeah, thank you. Castration. And I think it's chemical castration, which is not permanent. By the way, I mean, as a general matter, male castration can be reversed. Female castration cannot be reversed. So there are some differences there between men and women. Okay, anything else on this? All right, let's go on to a less, weighty case, which is the first one, which is Meyer against Nebraska. And let me give some background for this case. How do I put this? A dislike of immigrants is not new in our country. All the changes are the immigrants that are disliked. In the early 20th century, there was a very strong bias towards German immigrants. Germans, they're white, but yes, there was a very strong animus towards German immigrants. World War I didn't help that because we fought a great war against the Germans. In fact, in America, things like sauerkraut, which is a German word, was renamed Liberty cabbage, right? There was just it's true. There was a very strong anti-German sentiment in the United States, in particular in the Midwest. A number of states enacted laws that tried to promote assimilation, I can put it that way. And for example, Nebraska enacted a law that tried doing this in one particular respect. Who's next? Where am I up to? Yeah, Kimberly, thank you so much for volunteering. You want to give me the facts, please, in Meyer and against Nebraska?
Okay, so Nebraska criminalized teaching German, French, Spanish, and Italian to students until after they attained and successfully passed the 8th grade. And the purpose was to promote the speaking of English.
Okay, so I'm sorry, you're right. So they prohibited, what were the list of languages again? Okay. What languages were permissible to be taught?
Latin, Greek, and Hebrew.
Okay, thank you. All right, so they distinguish between what they call ancient or dead languages and alien speech, French, German, Spanish, Italian, etc. These were the tongues used by various immigrant communities, right? There's not much of a dispute, right? If you want to go learn Latin or Greek, right? If you want to go learn Hebrew or some of the other languages, you are allowed to do this. Okay. However, if you want to learn a modern language that's not English, you could not do this. Okay? All right. Now, Kimberly, how did Mr. Meyer get in trouble here?
So he taught a student German who
Uh-huh.
had not successfully attained and passed.
Okay. And in what context was he teaching German?
It was related to English, right? Or an English lesson or something in German.
Was an English lesson.
It was
What was he teaching? Yeah.
I'm sorry. It was religious.
Yeah.
something religious.
It was a Lutheran school, a private Lutheran school, and he was teaching Bible stories from in German, right? So at the outset, right, this is a very strange case to prosecute. This wasn't like a case where they were teaching, English as a second language and the instructions were in German. They were teaching Lutheran Bible stories. Martin Luther, right, the Lutheran Church, it was German, right? That was the Bible that was used, and they were teaching Bible stories. Okay, so folks, let me ask you a question. If today the government prosecuted a teacher for teaching Bible stories in a foreign language, how do you think that litigation would be presented to the court? We haven't done it yet, but just you got to take a guess. How right? If you go to a church on Sunday and you're studying German Bible stories, and government says no, you have to teach a Bible story in English. How do you think that litigation would proceed?
I think that, like, if the case is brought to the Supreme Court would, I guess, reverse that statute.
Okay, but on what grounds? What provision of law would that state law violate? Just get to guess.
I say 14th Amendment, personal liberty.
Well, more specific. It's about Bible stories.
It also in ties with freedom of religion.
Yeah, very good. Thank you. We have the First Amendment, right, which guarantees the right of free exercise of religion. If this case was brought today, I think it would be a First Amendment case, right, that the state cannot prohibit the free exercise of religion, right? Is it Angela, right? Angela, how come you think in 1924, when this law, I'm sorry, it wasn't 24, what year is it? I was off by a year. I know it was off. Sorry, I know almost all the years by heart, but something off by a year or two. So, Angela, may I ask this question, please? How come in 1923, Mr. Meyer couldn't go to court and argue that the state was violating the First Amendment? That the state was violating the Bill of Rights. Why couldn't Meyer make that argument in 1923?
I think it was because there was something about they disregarded the Bill of Rights.
Okay, you're right. What case did we study that talks about whether the Bill of Rights limits state power? It was a case we did about a week or two ago. Okay, so Barron was the original case. You're exactly right, from the 1820s, right? And Barron said that the Bill of Rights does not limit state power. There was another case that came later that reaffirmed Barron. What case was that? I'll give you a hint. It came after the 14th Amendment was ratified. Bingo. Say it louder. She's right. Cruikshank was the Colfax Massacre case, right? And remember, the allegation was that the lynchers, the lynch mob, violated the rights of free exercise, of freedom of speech, freedom of assembly and the right to bear arms. Cruikshank said that after the ratification of the 14th Amendment, Barron v. Baltimore was still good law. Right? That Barron was still good law. Everyone understand, right? So in 1923, when Meyer came to the court, Barron was still good law. Therefore, Meyer could not argue. He could not argue that his right to free exercise were violated because the states were not bound by the free exercise clause. Right? Designate. Instead, what provision of law did Meyer rely on in his appeal? It wasn't the First Amendment's free exercise clause. What did he rely on? Yes, exactly. And what was his argument? What did he contend?
He talked about the concept of liberty and freedom.
Good.
And how liberty isn't limited to freedom.
Good.
It includes like a wide range of freedoms, and then he started listing the different freedoms.
Okay. Okay. Very good. You're right. Okay. Meyer challenged his conviction, and Meyer argued that his conviction violated the 14th Amendment's due process clause. Right. Specifically, he argued his liberty was being taken away without the due process of law. Right? Now, in a minute, I'll talk about what liberty means. But Caroline, I want to talk about process for a second. Meyer was convicted, right, in court. There was a judge there. There was a jury there. He had an appeal. Caroline, was the process used to convict him improper? Was there anything wrong with the procedure that was used to lock him up? Actually, they had a fine, but to give him a criminal sentence. Well, was the judge fair? Is there any allegation that the judge was biased? Okay. Caroline, is there any allegation that the jury was rigged and that the jurors were bribed or anything? Was Mr. Meyer denied an opportunity to defend himself in court? Okay. So even if we assume for the moment that his liberty was violated, the Constitution says you can take away someone's liberty if you give them the due process of law. Let's assume he's right about liberty, right? Okay, fine. We took away his liberty. We locked him up for teaching German, but he was given the due process of law. Why does this trial violate the 14th Amendment, right? If he's given process, if he's given a procedure before he's incarcerated.
Are you asking?
I'm asking, yeah.
Well, I guess you're getting it. They're really talking about
Okay. She's right. That's exactly what I'm getting at. Thank you. You saw where I was going with that, right? This case illustrates, I think, very directly the nature of substantive due process, right? Even though Meyer was given a trial, there was a judge. I think there was a jury. I'm not even sure, but let's pretend there was a jury. There was a judge. There was a jury, right? There were all of the elements of fair process. But the attack here wasn't on the trial. The attack was on the substance of the law itself. And the argument from Meyer is that the law itself was not valid. In other words, there are some liberties that are so fundamental that no process will justify their deprivation. Again, there are some liberties that are so important, so fundamental, that no process can justify their deprivation. Or let me say it differently. There are some liberties that are so fundamental that a law depriving them is not a law, right? That a statute that deprives one of these freedoms cannot be considered a law at all. You cannot have the due process unless it's due process of law. And if this statute cannot be considered a law, it's void. And the argument goes the courts can step in and declare this law invalid. Everyone just get that distinction, right? The argument isn't that he was given an unfair trial. That wasn't what he raised. He argued that the law itself on its face was not really a law because it was unreasonable, that it wasn't properly justified. Why the law is unreasonable we'll get to in a few minutes, right? We'll discuss the rationale, but everyone get the basic frame of how he challenged this regime. Okay? All right. Good? All right. Brendan, let me ask you a question. So the next question we have is, what is liberty? And we spent now, I guess, about 2 or 3 weeks on this phrase liberty. And people disagree about what liberty means. And did I tell you the Lincoln story about the wolf and the sheep? Yeah, I'll give you this one. I forgot it earlier. Abraham Lincoln had this famous story. He didn't make it up, but he often told this. And he said liberty means different things to different people, right? Imagine that you are a sheep, right? And you're afraid of the wolf. The wolf's going to come eat you, right? And the shepherd comes along and protects you from the wolf. For you, that's freedom, right? You're free to live, right? The shepherd is your liberator, right? The shepherd is keeping you alive. He's giving you freedom. Okay. Let's say you're a wolf and you're really hungry, right? And you want to eat some sheep. And you see a sheep, you want to go eat it. You'll keep alive, you'll die otherwise. And this mean shepherd protects the sheep. That same shepherd is your oppressor, right? He is denying you what you need to live your life and be free. Right? The exact same situation. The same person is either a liberator or an oppressor, depending which angle you view it from. The exact same person. So Lincoln says liberty depends where you're standing from, right? Where are you depends on who is fair to you, who's not, right? That the liberty that you have depends how you interact with others. So people don't always agree on liberty. And look at Justice Holmes, for example. He doesn't think much of the liberty of Carrie Buck to have any sort of reproductive capacity. Doesn't think much of it at all. He thinks more of the societies need to become more prosperous and more free from these imbeciles. Right? So Brandon, how does the court go about defining liberty in Meyer? How does the court go about defining that term?
Well, they talk about a lot of cases where certain liberties are protected. Right to contract, occupations of life, acquiring useful knowledge, marry, establish a home, and bring up children.
You're right. You gave me a good list, but my question is different. How do they come up with this list of rights? You're exactly right with the list you gave me. That's Justice McReynolds puts together this list of rights. But how does he know that these are the rights protected by the 14th Amendment?
I just had to look at common law.
Common law, okay, that's a good answer. How do you know what the common law says? Is there a restatement of common law? Is there an opinion? Is there some sort of document we can look to?
Those rights were protected in the past.
Those rights were protected in the past. Let me ask you a follow-up. I wasn't going to, but now I will. Is the fact that we protected some right in the past mean that we can't cease protecting in the future?
Not necessarily.
In other words, are we frozen in time? That if at some point in the past we found something important, as a society can we change our minds and go a different direction? Sergio, where does this list come from? He lists, I'll read it to you. It says, freedom is not merely bodily restraint. I'm sorry, it's not merely freedom from bodily restraint. Freedom is also the right to contract, to engage in common occupations. Think of the butchers and slaughterhouse, or the bakers and Lochner. Right, to acquire useful knowledge, to marry, establish a home and bring up children, to worship God according to the dictates of his own conscience, and generally to enjoy those privileges long recognized at common law as essential to the orderly pursuit of happiness by free men. So, Sergio, it says it comes from common law. How do we know that? How do we know that this is a list of rights that the 14th Amendment incorporates? How do we know that?
I don't think we know that. I think it's just like liberty is ambiguous. So I think we're just using the common law to get closer to the definition.
But, you know, maybe the courts protect one set of rights and the 14th Amendment protects another. How do we know that let's just assume these are common law rights. We'll just pretend for a moment, right? How do we even know the 14th Amendment incorporates common law rights? How do we know that?
I don't think we do.
This case was 8-1. Or I'm sorry, 7-2, it wasn't close. Were these judges sitting there in the 1920s just making crap up, or were they ruling based on something more profound? Nick, I think, and Braden had your hand up a minute ago.
Are there general principles that go along with the way that common law had developed, like say principles of property law?
How is a judge to know what these principles are?
And there are opinions that other judges wrote.
Look, we had the slaughterhouse cases, right? The slaughterhouse cases said, yeah, you can shut down butchers in Louisiana. You can shut down their shop. How do we know? Braid?
Does that have to do with Corfield?
Corfield, talk about privilege and immunity. That's a good guess. But if that's the case, then these rights were recognized for a very long time. Why do we need the 14th Amendment? Angel? It's in the Constitution. We're in the Constitution. Okay, so some of it is written, and some of it is implied. What do you mean implied? Right. So this is the magic question, right? How are judges to interpret things that aren't written down, right? How is a judge to know what rights protected if it is not enumerated, if it's not written down?
Some judges follow what has been done in the past.
Some judges follow what's been in the past, but what if they're doing something new? This is the first time the court ever said these things, right? This was new. Oh, the legislature can always make rights, right? If we want the legislature, but this is saying that the 14th Amendment, ratified in 1868, protected these rights.
Are you getting at if the means justify the ends?
I'm getting there in a minute. That's the test they come up with. But my point is, before we even get to the balancing, how can a judge decide what liberty is? There's an amendment in the Constitution, which I don't think I'll mention again after today, but it's one that Randy writes about a lot, which is the Ninth Amendment. And the Ninth Amendment is somewhat, mysterious. It doesn't play much of a role in constitutional law today. But the Ninth Amendment says, you just take out your constitutions, the enumeration, page 68, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. And this is sort of what Angelo is getting at, right? The notion that there's some rights that are enumerated and other rights that are not enumerated. And the Constitution says we should not disparage or treat differently those rights which are unenumerated. Great. But who's to say what an unenumerated right is? How do we know what those rights are? What are the rights retained by the people? Robert Bork, who we mentioned before, he was the guy who fired the special prosecutor in the Watergate scandal. Robert Bork was also nominated to the Supreme Court, and he was very famously asked, what are these unenumerated rights? What are these rights retained by the people in the Ninth Amendment? And he said, imagine the Constitution had an ink blot, right, where it says, you have the right to do X, Y, and Z, right? And then someone just spilled a puddle of ink over that sentence. And we don't know what those rights are. Bork says, how is a judge to know what's under that ink blot, right? How can we know what these rights are? Bork says, because I don't know what those rights are, judges should not recognize any unenumerated rights. Let the Congress, let the legislature figure that stuff out. Okay. Well, if Bork is right, maybe Meyer is wrong, right? Maybe if the state wants to ban teaching of German, it's a terrible idea, but there's nothing expressed in the Constitution that says otherwise. And that's more or less what Holmes is getting at, right? Again, it's really easy to dunk on Holmes. I know, but the reason why Holmes is in there is to make you think, right? What is the basis of majority opinion? Is there, in fact, this common law right to raise your family, to raise your children? And if this right exists, why can't the legislature of Nebraska change it, right? The legislature can always overrule the common law. You know that, right? If a judge makes a common law ruling, it can be changed by statute. Because the argument here isn't that the common law prohibits this, it's the Constitution that the 14th Amendment ratified in 1868 prohibits this Nebraska law, right? Can we use the 14th Amendment to become a censor of state legislation, to declare unconstitutional laws that we may not like? Is this just not Lochnerism, right? That there's an economic policy that people disagree with, or there's a social policy they disagree with, and they go to the courts to the legislature, right? Can't you repeal the statute rather than go to the courts? Yes, Rosh?
So I feel like the way I was reading this was that although like this is all based on common law, but one codification of this, at least when it came to education and increasing in the knowledge, came from the Northwestern Ordinance of 1787, which kind of talks about religion, morality, and knowledge being necessary to good government and the happiness of mankind in school, and the means of education shall forever be encouraged. Meaning this is like a celebrated American value. So
A celebrated American value.
those are my words, not the words of the court.
No, I know it's a fair. I mean, it's a fair description, but what if someone disagrees, right? You're taking a very general principle, which I think is what Nick said before. You're taking a very general principle and using that to develop a constitutional right. You know, let's think back to Slaughterhouse, right? When we asked, how do you know that the right to contract is protected by the 14th Amendment's Privileged Communities Clause? We looked at the Civil Rights Act of 1866, the Freedmen's Bureau Act, right? There's some laws we can look to decide what these provisions meant. What about this other stuff, the right to raise a family, the right to have children, right? Do you remember anything in our discussion of the Reconstruction Congress about families and children? I don't think it's there, right? Now, to be sure, the state had never tried to regulate families, right? The state had never tried to regulate children. This was new, right? These are progressive laws designed to try to improve society. So maybe the argument is this is unprecedented, right? It's novel. And because Congress has never, because the states have not done it before, that means it's illegal. Is that the argument, right? That if something's always been allowed and then it's suddenly banned, does that mean that now they're going against the right? You know, I'll use abortion as an example, right? Traditionally, an early stage abortion was simply impossible because women didn't even know they were pregnant until fairly late on, right? Often there was no sure sign of pregnancy until much later. There's also not any real way of performing them at some junctures. Right? So the fact that maybe society in the past allowed abortion earlier and perhaps banned it later, does that mean that there was a right to abortion at that point in time? You'll see this argument in Roe v. Wade. The fact that abortions were only banned after what's called quickening, when the baby starts moving around, does that mean that before quickening, abortion was protected as a right, or just states didn't ban it? How do we extrapolate from the fact that society allowed some conduct to go forward? Does that mean that society just didn't care, or they thought that that was something that should be protected? And cannot society then change its mind and ban it later? you can see once you go from teaching German to abortion, it gets very complicated very quickly. But these are the same issues that will repeat throughout the semester. All right, so any other questions on how to define what liberty is? All right. Let's go into the other part of the opinion, which I think is a little bit more clear, right? Once the court says that there's some fundamental liberty at issue, then we have to decide, is the state justified in depriving people of that liberty? Right? Once you've identified the liberty interest, you ask, is the state justified in depriving people of that liberty? This case implicated 3 liberty interests. One of which is education, the right to learn. The second was the duty of the parent. That is the right of the parent to dictate how his child is raised. And the third liberty is the right of the teacher, right? The right of the teacher to earn an honest living, to pursue a calling. This is the same right that was asserted by the butchers and slaughterhouse and the bakers in Lochner. All right. Everyone with me so far? The court, and let me show you this graphic, if thing helps. The court's analysis in these cases, in many cases, employed what might be called means ends scrutiny, right? Means ends analysis. The court tries to figure out, is this law justified, right? Is this law have enough support for it? And then they ask a couple questions. So first they ask, what are the ends, right? What is the state actually trying to achieve here? What's their goal? And here the goal is to promote the public welfare. It's to improve the quality of its citizens physically, mentally, and morally. That is, ensure that the entire populace can speak English as a native tongue. Now you might say, Josh, that's not legitimate. Why does the state have an interest in homogeneity and assimilation? All the justices agree on this front that that end is legitimate, right? But I want you to think about this. Once you say the courts can decide if an end is legitimate, that is the court expressly deciding the wisdom of the legislation, saying, well, we don't think this is a legitimate end, or we do think it's legitimate, right? You may say, sterilizing people to keep them from reproducing is illegitimate. They thought it was legitimate, right? Once you allow courts to assess the ends, you're giving courts the ability to say, no, you guys are ignorant. This law is improper. That is not a legitimate state interest. That's powerful, right? I don't want to move over that point too quickly. Courts now can decide if the legislature was doing the right thing or not. And what possible basis is there to decide that? Oh boy, right, Richie? How does a court go about deciding if the goal, the end, the purpose of legislation is legitimate? Just how on earth can a judge make that sort of call?
Well, this court, they talked about Plato, and I went back to his welfare, or the ideal of the Commonwealth.
Very good. Plato, my God, right? I feel like Philosophy 101, right?
Yeah. They referenced that, and I guess they were talking about like the ideal civilization in regards to the upbringing of kids, for those who have inferior offspring, things like that, to have a better society later.
Okay, very good. But Richie, you gave me a correct answer for this case, but in general, how should a court go about deciding, right? How should a court go about deciding if an end is permissible?
I mean, I guess it would just depend on each case.
That's a good answer. This is something that should make you just feel just the slightest bit uneasy, right? Just the slightest bit uneasy. For a judge to decide if some legislation is serving a legitimate end, they have to draw on things not in the law, right? There's no clear standard to answer this question, right? There's no restatement of legitimate state purposes, right? Let me put this point bluntly. The fact that the legislature voted on this means they thought it was legitimate, right? The fact that the Nebraska government approved this law means they thought it was legitimate, right? Government doesn't approve laws they think are stupid. They do it for a reason. For the court to come and say, no, 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 that is not legitimate, it's say that the members of the legislature were wrong, that they were ignorant, that they were bigoted, right? And maybe they were. I mean, maybe we can all agree on a case, like, Buck v. Bell, for example, right? But there are other cases that can be closer, right? Has a court decide whether the end is legitimate, whether it's compelling, whether it's justified? That's a very difficult question. Okay? This is why substantive due process becomes so controversial, because it gives 5 judges in the court the power to second-guess the wisdom of an entire state's legislative branch and the governor and the voters. They're all wrong. Right? This is why Robert Bork says, I'm not getting involved with this. If there's no clearly expressly enumerated right, I'm going to defer and just presume the law is valid. Right? I'm going to presume that they're acting lawfully. All right, so that's the first component, the ends. Josh, let me come down to you. The next we look at is the means, right? How does the government go about actually executing this goal, right? How do they achieve this end? And here, the court says, and here Nebraska bans teaching of foreign languages, right, Josh? They ban teaching of foreign languages, right? So we ask, what is the connection between the means and the ends, right? Is banning the teaching of a foreign language a valid way to promote the public welfare? Josh?
They don't seem to think so here.
Why not?
They believe it oversteps the power of the legislature and interferes with his rights.
How do we know, though, that it's not justified? What tells us that? What test does a court give to determine if the means justify the ends? The court gives a test. It's on the screen. Thank you. Yeah. What does that mean, though? What does that last sentence mean, the reason relation part? Josh, what's a reasonable relation? What does that mean? What does it mean to have a reasonable relationship between the means and the ends? What does it actually mean?
I wasn't quite really getting it, to be honest with you. So.
Okay, let me ask you a follow-up then. Let's say that the state wants to have an educated population, right? And they require people to attend school through the 12th grade, compulsory education, which I think almost every state in the union has. Is a reasonable way of achieving an educated population to require compulsory education? What would you say? Sure. Why? Does forcing people to go to school for 12 years deprive them of their freedom? Ask if you have any kids when they try to wake up at 8 o'clock in the morning to go to school. What are they going to say? Hell yeah, yeah. You're all here at 9. You don't want to be here, I don't think. I mean, maybe you do. I hope you do. I do, at least. Right? There's some means that will pursue this end, right? If the goal is to improve its citizens, having compulsory education K to 12 would be justified, right? There's a reasonable relationship between having compulsory education and having an educated populace. But Hannah, let me ask you a question, please. What's the connection between banning speaking foreign languages and having an educated, healthy population? What's the connection there?
Between banning foreign languages and what?
And having a strong, healthy population, an educated population. What's the connection there? In other words, does banning the teaching of German make society more educated?
No.
Okay, so I'm going to ask a follow-up in a second, but of course not, right? In fact, it makes them less educated, right? Right? If your goal is actually to have an educated population, banning a language actually makes them less educated. But let's say, Hannah, that the goal is more specific. It's to have a population that speaks English, right? And the state says, well, if we want people to speak English, the more time they spend studying German, the less time they spend studying English. Shouldn't we promote people only speaking one language? Why would that be reasonable?
I mean, no.
Why not? If the goal is to get people to speak English more, why can't we require only English to be taught?
Maybe just requiring only one language won't make people more likely to.
Well, let's say they're 8 hours in a day. If you spend 4 hours studying English and 4 hours studying German versus spending 8 hours studying English, you'll learn English quicker, wouldn't you? Again, I'm defending Holmes here, right? Again, I don't like Holmes. It's easy to dunk on him. But the entire premise of what's reasonable is a judgment call, right? It's a judgment call. If the state says we need people studying English and only English so they can speak English fluently, then this law, I think, makes some sense. Again, you don't have to agree with it. But if the state's goal is to get people speaking English, requiring them to only speak English gets there. But that's not exactly their goal, because they allow teaching German and Latin and Greek. Right? Huh. So Ethan, what do we make of the fact that it's not only about speaking English, they can learn these other languages? How do we factor in that they can study Greek and Latin, these other sort of dead languages, which people don't speak, going around the store, going day to day. And the Nebraska government doesn't have, debates in German, in Latin.
So I believe the court makes note of the factor that because the statute leaves complete freedom for other languages, that it seems that it implies that there's no adequate foundation for the suggestion that.
Oh, so is their goal actually to get people to speak English?
No, sir. It seems as though it's just a mere pretext.
Pretext. What's a pretext, Ethan?
Something that is done for a different purpose than stated.
And what's the pretext here?
That they're possibly discriminating against.
Bingo. Means and scrutiny is designed to figure out if there's a pretext. Right? One of the goals of this sort of means and scrutiny is to determine whether the stated justification is the real justification. Right? And you do that by comparing the means and the ends. Right? If your goal is to get people speaking English, why are you allowing them to study why are you allowing them to study Latin and Hebrew and Greek? Right? The fact that you let them study some non-English languages, but not other foreign languages, means you're not actually trying to get them to speak English. It means you're trying to punish immigrant languages like German.
Can you repeat that stated justification?
Right? The goal, the means, and scrutiny is to determine if the stated justification is not the real justification. That is, the reason you gave in court is a pretext. Right? It's just a smokescreen. It's a, it's a reason, but not the real reason you're acting. Right? And here I think the court says this is not about promoting English as a language. It's about punishing immigrant tongues. Everyone get that? I think Ethan said it very well. Yeah, Nick?
So what about the whole 8th grade thing? I mean, they weren't saying you can't speak German at all or you can't learn German at all. They just, you got to be a certain age.
Well, what would Holmes say to that? Holmes would say, so what if they're trying to punish immigrant tongues? I'll put this question to Matthew, right? Or I'll give it to you, Nick. Matthew will be on deck. Nick, let's just say the state changes their mind. They come to court and say, you know, Your Honor, we're banning German because we don't like immigrants. We want people to be American. We want them to speak English. We're okay with Latin and Greek. These are sort of classical languages. We don't want immigrant tongues. What if they just said that?
Well, honestly...
Would that be unconstitutional?
Do you want like an objective opinion or my personal
Oh,
opinion?
give me both.
I mean, objectively, yeah, kind of unconstitutional. But I was reading it thinking, you know, like we're coming off the heels of the First World War. You know, Germans were the bad guys, weren't they?
They were the bad guys, yeah.
So I think there was a little bit of that involved in this. I mean, Italian too, I think, was a banned language. I think they were just
Spanish too. Well, French.
Well, I left those out for a reason.
Okay, but let's go back to the objective for a minute, right?
Okay.
Why can't the state punish teaching foreign tongues because they don't like those foreign tongues? In other words, why does the state have to act with a proper motivation?
Well, because it infringes on your rights.
Says who?
Says.
Why does the state have to act with goodwill to all? Lots of laws are punitive.
Is that the 14th Amendment? No state shall deprive
liberty, but that's the point, right? Why can't the state why can't the state say, we don't like this, we're going to ban it? In other words, why does the state have to act with a certain type of goodwill or proper motivation? Where does that come from?
the 14th Amendment.
We did one case that might be relevant, which was Yiquo, the idea that if you act with an evil eye and the unequal hand, right? But why though? Why does banning foreign languages with an improper intent violate the 14th Amendment?
I guess there's just like this greater good that people should be able to do what they want.
The greater good, my God, the greater good. And Justice McReynolds tells us what the greater good is, right? He knows better than Nebraska. Why isn't the greater good to try and promote a strong culture that promotes English as a first language? Is that a greater good? Yes. They don't. They don't. In fact, the allegations were that people would speak foreign languages at home. They speak at school. They weren't learning English as part of the society. Right? I mean, again, nothing's new, right? The same sort of stuff you hear today was 100 years ago. The exact same stuff you hear, right? But I think Angela urges a fair point. This means and scrutiny is firmly rooted, right? Courts do it all the time. I think they did in Yiquo. They said, how can it be that all the Chinese people apply for licenses got denied, but all the white people apply for licenses got them, right? How could it be? Was this actually based on public health and safety? No, it was based on what you might call an animus towards Chinese people. I think you see a similar type of framework here. How can it be that you can speak Greek, you can speak Latin, you can speak Hebrew, but you can't speak like German, right? Is this actually about promoting public welfare? No, it's about punishing immigrants. What we see in these cases, the court says, I don't like this, right? I think that this goal is not in the public interest, that you're acting with an improper intent. Therefore, we're going to stop it. My question to Nick, which he deftly dodged, is why is this the 14th Amendment's goal, right? Does the 14th Amendment require the government to act with a proper motivation? And can the court then stop them from acting with an improper motivation, right? Where does that come from? This is a judge-made doctrine. That's the only answer I'll give you. The judges developed it. You see it in Yiquo. You see it in Meyer. You see it in Pierce, the next case. You don't see it in Buck. Do not see it there, right? But you have this job where the courts decide, I don't like where this law is headed, so I'm going to stop it. You have Holmes, right? Holmes is like this guy saying, what are you guys doing, right? What are you doing? Right? Matt, you want to give me the Holmes dissent? By the way, the dissent here by Justice Holmes wasn't in the Meyer case. It came up in a what's called a companion case, another case decided at the same time. This one was from a case from Iowa. I didn't know this dissent existed until a couple of years ago, right? I was always saying, how come Holmes did dissent in Myers? But he did. He dissented in all these cases. Most case books don't have the Holmes dissent here, but you guys have it. So Matt, you want to talk to me about the Holmes dissent for a minute?
So he found that the law was proper and it was a desirable end that all citizens of the U.S. would speak a common tongue. He thought the means of reaching that was also reasonable.
Reasonable. See, the exact same framework, right? I'll come back to you in a second, Matt, but I want to interrupt for a minute. The majority of the dissent use the same framework. They both use means and scrutiny. They both agree that having a common society is a legitimate end. Where they disagree is on whether the means chosen were reasonable, right? Whether the means chosen were reasonable. The majority says these are not reasonable means. The dissent, Holmes, says this is reasonable. Who is to decide what is reasonable and what is not? Think back to your torts class, right? The reasonable man standard, right? The reasonable person standard. I hated that unit in torts because I don't think I'm very reasonable, right? I'm the eggshell, whatever it was, right? The egg skull shell, whatever, right? Torts is my worst class in law school. I did not do well in that class. I still don't get negligence to this day. It just doesn't. I truly don't. Maybe I'll learn it one day. I'll sit in your class sometime. But what is reasonable? Who gets to decide what reasonable is? Holmes says if the people of the legislature decided this, that's enough for me, right? This is a question on which men might reasonably differ. Let the experiment be tried, right? If people disagree on this, let the states experiment. Let them give it a go, see what happens. This is more or less his dissent from Lochner, right? Where he says the 14th Amendment does not enact any particular school of thought. And it's not for us to try to dictate what this means. Right? So there's so much that turns on this word reasonable, right? What is the fit between the means and the ends? Is it a reasonable relationship, or is it a very a stretch, attenuated relationship? Okay. Depending on how the judge defines this word reasonable, or maybe rational, these different words, it dictates the outcome of this case. And invariably, my friends, it's a judgment call. It's a judgment call. The judge must draw on something in his mind, in his experience, in his wisdom, to decide whether this law is reasonable. Holmes would simply say, I don't have enough to make that call. I will simply defer to the democratic process and go ahead. Second, Nick. Now, you may like that opinion until you get to Buck v. Bell, right? Because in Buck v. Bell, Holmes used the exact same approach he did in Lochner, the exact same approach he used in Meyer, right? The exact same approach he used in these other cases. Say, well, this is not for me, right? If the people of the state want this, who am I to stop them? Nick.
Isn't it like one of the roles of the judge to preserve the law as it's written? So Holmes is.
Well, what's written here? Is there any written right to teach children? Is that written anywhere?
No, but if the legislature wrote something down,
yes,
it becomes law, and isn't one of the roles of a judge
to uphold what the legislature does?
Uphold what the legislature.
That's what Holmes does. Holmes says, if the legislature thinks this law is reasonable, who am I to disagree? But now, Nick, the flip side is Buck v. Bell. They wrote down that law. They wrote down the sterilization laws on paper. I can show you a copy of the bill. Right? If the court's job is simply defer to the democratic process, then what's the role of judicial review? Now, perhaps the flip side is when there's some clear constitutional prohibition, right? You can't have ex post facto laws, right? You can't suspend habeas corpus. Maybe if that's even clear, right? Courts can intervene. But this entire topic is not about the Commerce Clause. It's not about necessary and proper, right? It's not about something straightforward. It's about what liberty is. And the Holmes approach is, well, we don't know what liberty is, so we simply defer. We'll let the legislative branch decide what freedom is.
But then, couldn't you argue that the case that brings us to this precedence of judicial review, where did Justice Marshall get his concept of, I can't look at this case because it's not in my jurisdiction? Because he basically defined what his jurisdiction was.
Well, there was a statute, though, right? Right. You can criticize Marbury for a very long time, which I'd be happy to do. But there was a provision of the Constitution which says that the original jurisdiction is set by the Constitution, not by statute. Right? I don't think that's the best reading of the Constitution, but it's a plausible reading, right? Can the court expand the can Congress expand original jurisdiction? Right? That's a reasonable reading of the Constitution. I think Marshall misread the statute, the Judiciary Act of '89, but I think his reading was plausible. But here, we have the word liberty. It's all we got, right? There's nothing even close to a clear answer here. And they found these common law rights which now become constitutional rights. It's of a different nature, right? Again, if there's something clear, right, it says the original jurisdiction of the Supreme Court is X, Y, and Z, it's plausible that that's all it is. You can't expand to it. But here, it's just this liberty. All right, so again, you can favor judicial review in the John Marshall sense without favoring the sort of progressive era judicial review in Meyer. They're of a very different nature. Any other questions on the majority opinion or the dissent in Meyer? No, this is why I made the class so short for readings. This one, I used to rush this topic. Now I don't have to anymore. I'm grateful for that. Usually the discussion was cut in half. Anyone else on the Meyer? Okay. Let's go into the next case, please. Meyer v. Nebraska was 1923, and about 2 years later, we get Pierce versus Society of Sisters, 1925, and both opinions were by Justice James McReynolds. Just one note on Justice McReynolds. He's not a very popular justice. For one, he was a rabid anti-Semite. He hated Louis Brandeis, another Jewish justice. He would often turn his back to him. He's not a well-liked guy in the court. He was very angry, very cantankerous. He's a graduate of UVA, University of Virginia. Virginia has one Supreme Court justice to their name. They never claim him. Right? They don't even acknowledge him. He was not a well-liked person. But on these cases, he was pretty consistently voting in favor of a broad reading of the 14th Amendment. Okay. All right, who am I up to? Tanner, sir, do you want to give me the facts in Pierce?
Yeah, so it was Oregon, it passed the Compulsory Education Act of 1922.
Good.
And it required every parent or guardian or like another person in control of the child between the ages of 8 and 16 years to have their child in like a public school for.
Well, let me just pause you for a second. You're not wrong. Did the law actually mandate sending your kid to a public school? What did the law actually do? It's a distinction, but subtle. It's important. What was the actual offense that the law defined?
Oh, the actual offense, it was a crime. So
Crime to do what? What was the crime?
I thought that it was a crime if that a parent did not have their child in like a public school.
That's right. But were they required to send them to a public school? I know this sounds very funny, but in other words, could you send your kid to a private school, and just pay the fine?
Yes.
Yeah, let me just make that clear. This wasn't actually a mandate. This is almost Obamacare-ish, right? There wasn't actually a mandate to send your kid to a public school. But if you send your kid to a private school, you'd be fined criminally. Everyone see the difference, right? The state wasn't telling you what to do, but if you did the wrong thing, they throw you in jail. Yeah, nice, right? That's actually how most laws operate, right? It's not that you have to do something, but the failure to do it means you get penalized. basically Obamacare. This is basically the John Roberts opinion. I will move on. Okay, so Tanner, the law penalized and criminalized sending your kid to a public school. I'm sorry, to a private school. What would the effect be of this law on all the private schools in the state?
For the parents, they would send them to like a public school in order to avoid having to pay the fine. So it would hurt with the private schools, with the funding.
It's shut down, right? If it's now a crime to send your kid to the private schools have no business, right? Who's going to maintain a school with 0 students, right? They'll go out of business. They can't. Everyone with me? Okay. Now, Natalia, if I told you that there was a law that made it a crime to send your kid to a private school, who do you think the ideal plaintiff would be to challenge this law?
The private school.
Who would be even better than the private school? The parent. Everyone think about this, right? Why is the plaintiff here, the college, I'm sorry, the school, the military academy, the nuns, right? Why is the plaintiff here the nuns? Why isn't the plaintiff the schools? Why the parents? Why do you think the parents weren't the ones bringing this case here, Natalie?
Well, because here they could still choose at the end of the day to send them to public or private just for the fine.
Yeah.
So,
Right. Anyone else want to, Nick, was your hand up? No. When you have this sort of litigation, it's expensive and time consuming, right? Most parents don't want to deal with this crap, right? They don't want to have to go to the courts to litigate this. The better plaintiff was actually the nuns, right, or the military academy. But the fact that that's the nuns, the military academy bringing this case raises a separate question. Do corporations have constitutional rights? Do corporations have rights? The answer was 9-0 yes here. It wasn't even a close call, right? This wasn't even a close call. But the important point is you have these corporations asserting the rights of their students, and the corporation was asserting the rights of the parents. And this creates a question, right? How can a business assert the rights of its customers? We'll see this in other cases where you have abortion clinics like Planned Parenthood who are asserting the rights of women who may seek abortion in their facilities, right? We'll do cases where there's one state banned the sale of beer to underage men, but not underage women, right? Who brings a lawsuit? A convenience store that says, I want to sell beer to men and women alike. So this is a weird facet of constitutional law that I'm not exactly sure is correct. The court may actually revisit this issue very soon in an abortion case. But the issue is this. Can third parties assert the rights of their customers? Students, teachers. The court kind of assumes that's the correct answer. I don't know if that's even right, but that's been the law now for 100 years or so. All right. Everyone with me? All right, so David, let me ask you a question, sir. Let's say today that the state passes a law that makes it a crime to send your kids to Catholic school. The nuns go to court, right? The Little Sisters of the Poor, right? The Sisters of the Holy Names. I have an amicus brief for the Little Sisters coming out next week, so they're on my mind now. What provision of law, David, do you think the nuns would raise if there's a law banning the attendance at private school? This was my same question to Foss a few minutes ago.
I mean, just like a religious school or just any private school?
I said the nuns. I didn't get to the private school, just the nuns for a minute.
I think the nuns would raise I know in this case they kind of relied on the fact that it was harming their property.
Good. You're right. But what if this case is brought today, what would the nuns rely on? What provision of law? I'm sorry?
I'm not sure about that.
Same question to Foss a minute ago. Remember what the answer was there?
No, sorry.
Nolan?
Free exercise of religion.
Free exercise of religion. Yeah. Again, if this case was brought today, they would raise free exercise of religion. Now, David, the follow-up question is this for you. Why didn't the nuns raise free exercise of religion in 1925?
When that was enacted yet, was it?
It wasn't what?
Like that exact provision wasn't there yet.
The First Amendment? Nolan?
It didn't apply to the states yet?
It wasn't incorporated because of Cruikshank. This was Angela's question a few minutes ago. The same question twice, right? In both Pierce and Meyer, the court doesn't consider the First Amendment. Why? Because it wasn't incorporated because of Cruikshank and Barron. Right? This is the same issue before. Now that argument works for the nuns, but not for the other plaintiff, the Hill Military Academy. Right, the other plaintiff is a private college, a private school in the state that's not religious. The Military Academy. Okay. The Military Academy could not rely on the Free Exercise Clause because it wasn't religious. Now, why am I making such a big stink about the Free Exercise Clause? Today, in modern case law, the court has recharacterized Meyer and Pierce. Today, the court says that Meyer and Pierce were about the free exercise of religion. There were Bible stories. It was a Catholic school with nuns, right? Wrong. The court basically has created an alternate facts, if you will, right? They've recharacterized these cases. And the way we know they're wrong is the Military Academy. Right? The Military Academy was not religious. It was based, as I think David or Nolan said, on the 14th Amendment's Due Process Clause. All right. So Nick, walk me through, please, the court's analysis in Society of Sisters.
Well, they say that the society alleged that the bill violated the rights of parents to choose where their children can go to school, and the fact that their businesses were being destroyed and their property was being depreciated was a deprivation of their right to for the parents to choose where their children go to school, and I guess their right to have property.
Okay, very good. All right. So we start off with the 14th Amendment, right? We focus a lot on the word liberty, but here they focus on the word property, right? Liberty plays a role as well, but it's also property. If, in fact, this law goes into effect, people will no longer send their kids to a private school. As a result, the schools will lose money and will shut down. This, the court says, deprives them of their property. But wait a minute, that can't be right. That can't be right. Sarosh, how can it be right? Lots of laws restrict businesses. Think of the butchers. They have to shut down their butcher shops in New Orleans, and slaughterhouse, right? How can it be that a law that shuts down your business deprives you of your constitutional right? Why can't the state exercise this power, this police power, to ensure that children receive a proper education?
Well, if we're going back to the slaughterhouse cases, the government wasn't shutting them from exercising their practice. It was telling them they have to go to a certain place.
Okay, so now the nuns, instead of teaching there, the nuns should go work in the public school system. Then they can practice their trade.
They may not be qualified to work in the public school system.
Oh, maybe the butchers wouldn't be qualified either. But you're fighting the hypo very well. But the more basic point is, why can't the government shut down businesses that are inconsistent with state law? If there was a shop selling, liquor, right? Why can't the state ban alcohol and say, nope, you're not selling alcohol anymore? Not going to happen. Could they bring a 14th Amendment challenge?
It would be because their property, you're taking their right of livelihood.
How then does the state ever shut down businesses? Doesn't any decision to shut down any business deprive them of their property without due process of law?
Well, that's just it. They're not getting due process of law.
Oh, there will be a hearing. We'll give you a hearing first.
But again, we're going back to that's procedural.
Now, no matter what you say, you go back to the word law, right? Is this a valid law, right? Whether you start from liberty or property, you have to ask, is this law valid? Is this law reasonable? Is this law justified, right? That's what all these inquiries are. And the court here says that this law is not reasonable. right? It's not justified, right? The compulsory education law does not have a reasonable fit to a purpose within the competency of the state, right? Here they say that the ends are not legitimate, right? They say that the ends are not legitimate, that the state does not have an interest in dictating how parents raise their children. Can that be right? Yeah, is that right, that the state doesn't have an interest in deciding how children are raised? Is that possibly correct?
Are you asking me or just?
I'm asking you. Either.
No, I don't think so.
Well, doesn't the state require compulsory education K through 12? So why can't they dictate where those schools are?
Well, the court said that the state didn't own the children, and that parents and guardians had that.
You're right.
guarantee.
You're right. States don't own the children, but how come they can still compel children to go to school if they don't own the children? In other words, why can the state compel education in general, but can't compel where you gain that education? You can do one, you can't do the other, right? If you can say you have to go to school, why can't they say here are the type of schools you got to go to?
They said they didn't have that much power.
I know they just said, but why?
Regulate it.
But why not? Why, you're right. But how does the court know the state doesn't have that power? You're exactly right. But how do they know that? That's my question. And it's fine. How? She's struggling, and I think she's on good grounds to struggle with this question, right? How does the court know that they can do X but not Y, right? They can comply. They can require education, but they can't require where the education goes forward.
Don't they apply the decision in Meyer in regards to the desirable end cannot justify the prohibited, or cannot be justified by, cannot be promoted by.
But how do we know Meyer is right? See, now you see where this goes, right? Once you have one of these precedents, you go, oh, but this is like Meyer, right? And you build and you build and you build. We'll get to a point this semester where Justice Kennedy writes an opinion that basically just relies on his own opinions, right? The gay marriage decision of Bergefell is basically Kennedy saying, we have all this precedent that I wrote, right? So it's got to be right. Wouldn't that be great if I said, this is the rule because I said so, and I said so yesterday, which means it's really the rule, right? But how do we know this? Again, the state's effectively saying, the court's saying, we don't think this is justified, right? In other words, we think it's okay to dictate compulsory education, but not where the education takes place, because we don't think it's appropriate. There's not much more to it than that, right? Once you say this right exists, you say, okay, then what is the fit? What is the relationship? And this goes too far. Nick?
Well, don't they say that what the school is doing is useful for the end that the state is trying to reach for?
But the state disagreed, right? The court found the nun's instruction useful. The state didn't. Why is the state right, the nun's wrong? Right? Or why is the state wrong and the nun's right? Who's to say?
Well, based on what the judges say, they say that that the nuns were actually doing what the state wanted to do. They wanted to encourage proper education.
Yeah, but what if the state changes their mind and says, we don't think this is proper anymore. We want to have education under our control. We want to be able to dictate the lesson plans. We want to have control of the teachers. We don't want these rogue third parties, going off on their own tangents.
That's not what the state argued.
That's not, but I'm changing it, right? Why can't the state reasonably decide that these private schools are inadequate?
I mean, theoretically they can, but I'm talking about this case.
Oh, Nick, let me ask you the question. Why did the state enact this law?
They enacted this law to encourage the proper education of children between the ages of 8 and 16.
And what is implicit in that decision? They say, we want to encourage proper education, therefore we're banning private schools.
And the state thinks they are the best place, the best source of that education.
And they also think, what about private schools?
That they would therefore not be the best.
There it is. So, the legislature doesn't need to say with clarity what they're doing, but I think you can read between the lines of what they're getting at. By banning private schools, the state's saying, we don't think these are adequate. We want to have only the best, and these are not adequate. And if the state makes a decision, who's the court to second guess them? Now, Ethan mentioned a few minutes ago the concept of pretext, right? The real reason these laws were enacted was anti-Catholic bias. At the time, almost all the private schools in the state were run by the Catholics, the Jesuits, the various orders of nuns. Right? There's virulent anti-Catholicism, which we don't have, you don't see to the same extent today. But even when John Kennedy was elected president, as the first Catholic president, there was a fear that he was an agent of the Pope. Right? That he was an asset. Now we have Russian assets. Back then we had Catholic assets, right? Just nothing changes, right? That people are under control of someone else. We'd be the agent of the Pope. But this was designed primarily to shut down Catholic schools. The state says, oh, we have another rationale. We think the Catholic schools are inadequate. So I think here, once again, the court was saying, the reason you gave us is not the real reason. We're not going to say it, but we know it, and we're going to declare this unlawful.
But doesn't the Hill Military Academy bolster the state's claim?
Yeah.
Because that is not a Catholic school.
Which is why the religious argument doesn't go the way, which is maybe why Pierce is wrong. Right? I mean, again, you can agree or disagree with the outcome, but Holmes did not dissent here. I don't know that he even circulated a dissent. Maybe even he thought this went too far. Right? That even he thought this was a bridge too far. I don't know. But you're still basing this on some decision of whether this was a reasonable law, which is a judgment call. All right. Anything else, my friends, on Holmes? I'm sorry, not Holmes. On Pierce. Oh yes, sir.
So, if there wasn't this anti-Catholic pretext that the court doesn't have mentioned, but sees, do you think they would still rule the same way, that the state obviously has an interest in the child's education,
right?
But that what they're trying to do would go so far as to interfere with like a parent's right or interest in directing how.
Yeah, maybe that's the answer. Maybe the state can dictate education K through 12, but can't dictate where the education takes place. Right? Maybe a more narrowly tailored remedy is to require private schools to teach certain lessons, right? To engage in certain types of subject matters, right? That if you have X hours a day, you have a certain amount of religious studies and certain hours for non-religious studies, right? Maybe that's a better approach, but this one maybe just goes way too far. Yeah.
So if it wasn't for that pretext, do you think the court would have sided with the state?
I don't know. The military academy, I think, complicates that a bit. I think the court thought, based on Meyer, you can't tell parents how to raise your children, and this goes too far. All right. Questions on Pierce? All right. Meyer and Pierce were decided a couple years apart, and they're largely viewed today as like good cases, right? That these are the cases where the court got the right answer. Again, people don't like saying these were substantive due process cases, but they were. These are Lochner-style cases. They were not First Amendment cases. The next case is not viewed so favorably. If there is an anti-canon of constitutional law, this one probably belongs in it. Right? These are the cases that you should not be citing. But courts do cite these cases. Courts cite Buck v. Bell to this day. It's not overruled. It was favorably cited in Roe v. Wade. And courts cite it in lots of cases about sterilization. This is a harder case than you think. I know you can hate it, and I can hate it with you, but it's a harder case than you think. Let me walk you through the facts a little bit myself, and then I'll call on someone in a minute. In 1924, Virginia enacts two laws. The first law is called the Racial Integrity Act. This law prohibited interracial marriage. We'll come back to this case in about 2 weeks in a case called Loving versus Virginia. The court would find the second law to be unconstitutional. The other law enacted at the same time was called the Sterilization Act of 24. And this was a law that forcibly sterilized so-called imbeciles. Okay? It's hard to understand why this law would exist, but you need to put yourself back in the mindset of the early 20th century. There was a very prominent movement, a belief system, known as eugenics, right? What is eugenics? Eugenics is the notion that society can control its future, right? This caption says, eugenics is the self-direction of human evolution. Darwin's theories have become quite popular at this point, right? The notion of the survival of the fittest, and that in society, stronger people will reproduce, right, in the state of nature. But unfortunately, in our society, we've coddled them, and we've allowed these undesirable people to survive long enough to reproduce. The way to stop these undesirable people from reproducing is to stop them from reproducing. And that often took the form of sterilization. Okay? This was not some sort of fringe theory. This was a very well accepted, even popular branch of science. The same way we have any science today, this was considered science. And the notion was, we need to stop people from burdening our society, that we're going to run out of food, that we're going to run out of habitable space, and we need to stop these people from infecting our gene pool. States began to experiment with laws that allowed the government to designate people as imbeciles and forcibly sterilize them. Now, a couple states actually had challenges. In New Jersey, in Michigan, and Indiana, state supreme courts, state courts, found that these eugenics clauses violated their state constitutions. The state constitutions, right? Not the federal constitution. The people in Virginia decided to create a test case, right? They wanted a decision from the Supreme Court establishing the right to sterilize people. And this was the Virginia Colony for Epileptics and Feeble-Minded, where Carrie Buck was kept. So a law was enacted, a 3-step law. The first step is the government would recommend that a patient be institutionalized in the colony for feeble-minded people. I want to make this point again, I made at the outset of class. You will be locked up there for life. This was not like a 5-year sentence. So long as you were deemed an imbecile, you'd be locked up. And these were sex-segregated facilities. The idea was, we don't want these people reproducing, so we'll lock them for life where they can't reproduce. But then the state said, well, we don't have to do this. It's expensive, right? It's very time-consuming. We don't want to keep these people. If they're not dangerous by themselves, they're only dangerous if they reproduce. So we'll go to step 2. The court says that this is a candidate for sterilization and a guardian's appointed. Okay. And third, the county decides, should this person be sterilized? And if so, there's an appeal to the courts. Now, this might remind you a bit of the lottery, right? There's a process in place. It looks awfully fair, right? You have a guardian, you have the court, you have hearings. But what they're doing is insane, right? No, they're not stoning people to death because of their, put a little piece of paper with a black mark on it. They're sterilizing a person because they decide they're imbeciles. Like, what is the justification for this? You say, Josh, it's nuts. But at the time, this was science, right? Hashtag science. This was the, I get in trouble when I say that. This was the science of the day. Who are the courts say the scientists are wrong? The science is settled, as they say, right? It's always settled, right? The colony selected for their test case Carrie Buck. And this is Carrie with her mother, Emma. Why did they select Carrie Buck? The members of this colony want to demonstrate that imbecility was hereditary. That imbecility was hereditary, that you basically inherited these traits. So I think this graphic's in your book, but I have it on the screen as well. This was a family tree of Carrie Buck. And if you read it, it says, most immediate bloodkin of Carrie Buck showing illegitimacy and hereditary feeble-mindedness. Again, imbecility doesn't mean what you might call mentally handicapped or mentally retarded, which is not a phrase we use anymore, but that was a phrase used back then, right? These are people who were educated. Carrie Buck could read. She could write. We know this because we have letters from her, right? She was literate. She was not an idiot by any stretch of the imagination. Now, look at this family tree of Carrie Buck. Carrie's over here, and it sees it's F, right? That means feeble-minded. It goes up to her mother, Emma Buck. F, feeble-minded. Okay, goes down one level. Vivian Buck, at the time was about 6 months old. Also F, for feeble-minded. The government here wanted to show that the entire stock, the entire lineage, was infected. And that the only way to prevent this bloodline from corrupting our population was to cut off their ability to reproduce. Right? This is where Justice Holmes gets his line from. 3 generations of imbeciles are enough. 1, 2, 3. Okay? Now, the facts are even worse. First off, Emma Buck was not an imbecile. She apparently contracted syphilis. It happens, right? But that made her basically feeble-minded. Carrie Buck was deemed promiscuous in that she had a baby out of wedlock. She was raped. That's why she became pregnant at such a young age. And poor Vivian, the baby, was 6 months old and was deemed an imbecile. And let me tell you, I have a 10-month-old daughter now. At 6 months, they don't do very much, right? They kind of just ga. You know, they can maybe go on their tummy time a bit. They don't do much at that age. This was all garbage. It was all BS science. But this was put together to try to set up Carrie. It gets even worse. The attorney, the advocate they appointed on her behalf, was a board member of the colony, right? The person appointed to represent Carrie worked for the colony. He did not introduce any witnesses. He did not introduce any evidence. All he did was move along to ensure the Supreme Court could review the case. There was no adversity, right? So forgetting for a moment that this law is what it is, there was no process, right? That she was actually denied due process of law because she wasn't given a competent attorney to represent her, right? That's an easy way of resolving it. But Justice Holmes argues that this is not an attack on the procedure. It's an attack on the substance of the law. Okay? Now, the opinion itself is really short. You know, it's only about a page and a half long. But there's so much going on there. Who's next? I forget where I'm up to. You're. Oh, okay, yeah, your little notebook. That's cute, right? All right, Martin, you want to just walk me through the Holmes analysis, please?
So, essentially, applying the two generational rule plus the
let me ask this question, Martin. Does the court find that the end here is legitimate?
That the ends here are legitimate?
Yeah.
Yes, they do.
Yes.
Essentially saying like it's better for the world instead of waiting to think degenerate.
Yeah. Yeah. Look at this language, right? Just I want to just focus on language. We'll read some cases this year that are really harsh language. Dred Scott had some of that language. Bradwell, remember the Meyer Bradwell, the woman lawyer case, has some of this language. This case too, right? That the language is deliberately harsh, refers to these people as degenerates and imbeciles. Here, I think Holmes actually agreed with what he was writing. He emphatically agreed with it. But he makes this point that I phrased at the start of class. The government can imprison Carrie Buck for her entire life in this colony. Why should not the government have the power to do something less, which was sterilize her and then release her? Actually, Ruben, this was your question, so you're the guy. What does Holmes say about this point?
Well, like he said that the government has greater power to imprison an imbecile in a colony for life. The government has lesser power to sterilize the imbecile who can be excused from the colony. He talked about the alternative to life imprisonment was far worse.
Yeah, yeah. Holmes also explains that we send people to fight and die in war. I mentioned last week he was a Civil War vet, shot twice. Oh yeah, you like the animation? You didn't even notice it, did you? I'll play it here.
Premise. Because the government has the greater power to imprison an imbecile
There you go.
in the
Happy.
colony for life.
Hard at looks to make that animation, but there you go. It was a jail cell's closing. We originally had the sound of like doors clanking shut. We took it as a little too much. What was that?
That's what I was expecting.
I know it was distracting. We took it out. We spent so much time on these Fakakta videos. So much time. I actually have so much free time that I don't have to do this. I review these things hundreds of times. I have actually this respite now of productivity. But I think Ruben made the point well. The state can do a lot more stuff. Why can't they do something lesser? Right? You can send someone to war. Why can't you just prevent them from reproducing? There is no scrutiny whatsoever about the validity of the law. It was almost pure deference. Okay. Let me. I want to play a clip that comes at the end of this video. And it involves the Nuremberg trials. I'll just play this clip briefly. After World War II, many of the Nazis who were captured were put on trial. These were called the Nuremberg trials. And I think I'm wearing the exact same thing. And the I don't have many shirts. Since I wear the same thing almost every day. It's a white shirt or a blue shirt. There are not many options. But after the World War II trials, we had the Nuremberg trials, and Robert Jackson took a leave from the court to be a prosecutor. And one of the crimes that the Nazis were accused of was actually eugenics. That is, they were executing an entire race to prevent them from reproducing, taking a step further than what the Virginians did. During the trial, the Nazis actually read from the Holmes opinion. Let me just play this clip for you briefly.
The Nuremberg trials, attorneys defending Nazis for war crimes read from Justice Holmes' opinion. They sought to demonstrate that Americans and not Germans invented eugenics.
3 generations of imbeciles are enough.
It's not working for some reason.
You recognize it now, Dr. Beek?
No, sir, I don't.
Actually, there is no particular reason you should. Since the opinion upholds the sterilization law in the state of Virginia. It was written and delivered by that great American jurist, Supreme Court Justice Oliver Wendell Holmes.
We have now concluded our study.
So basically, the Nazis relied on Holmes. But again, it's easy to dunk on Holmes.
Faulkner and Atkins are no
It's
longer
very
good law.
easy to dunk on Holmes. But I want to just focus in the last few minutes about what the alternate position is, right? Oh, stop this. I'm talking, distracting myself. Okay, fine, stop. It's very weird to listen to yourself nonstop for like 2 years at a time. Just the same audio over and over again. Study God, study God, study God. It's drilled in your brain. But if Holmes is wrong, right, then what else is wrong? Can the state not incarcerate people for life? Right? Can the state not send people off to fight in war? Right? Can the state not make people engage in dangerous activities? If they can do those things, then why is it so different, right? Why is depriving someone of the capacity to reproduce that much worse than saying you're in jail for 50 years? It's not an easy question, right? There's just something special, because if you're in jail, you're not reproducing anyway. You don't have the capacity to do so, naturally. So you can't raise children, you can't see your family. All right. Any other questions in the Holmes majority opinion? There's just a lot there, and I did most of it at the start of class. There's no dissenting opinion. We have a dissent from Justice Butler, Pierce Butler, but we don't have a written opinion. That was somewhat common at half court, for there simply to be a dissent but no opinion. But leaves you a bit unsatisfied, because you don't have a contrary take, right? A dissent plays an important role. I think Justice Ginsburg described it this way: a dissent speaks to future generations, right? To a different era when people see things differently. Justice Scalia would say his dissents were written for law students. He said, I write my dissents to get attention in law schools. That way they pay attention to me. It works, right? I'm still teaching him. I'll be teaching for a very long time. But there was no dissent here. No one was there to call out the court on this sort of insanity, right? Of what the hell are you guys doing? And often a dissent will make certain accusations, and the majority sort of waters it being down. It's like, okay, fine, I'll pull back a little bit, right? We don't have that here. So in a case with no dissent, we don't have another opinion. There's no Harlan, right, in Plessy, right? Or there's no Harlan like in civil rights cases, right? Think of Bradwell, right? Justice Chase was too ill and he couldn't write an opinion at that point. So we don't have a dissent for the attorney who wanted to be a member of the bar. So it's unfortunate we don't have a dissent, but this was the opinion there. Okay. Any other questions on Buck? All right, let me summarize our past couple classes, and I'll bridge you for the next class. We've now done, I think it's about 7 of these due process cases. They fall into these 2 broad categories, what we call economic liberty and personal liberty. Lochner, Muller, Buchanan, and Atkins involved economic liberty. Meyer, Pierce, and Buck involve what you might call personal liberty. Now, that's the label we use today. That's the modern day label. These labels did not exist at the turn of the century. These were not concepts that were known. Why am I separating these 2 categories? The short answer is the green cases, Meyer and Pierce, are still good law, right? The court still recognizes this as good cases. But the red cases, like Lochner and Atkins, where the court declared economic laws unconstitutional, are not good law. When you get to the 1930s, and you're reading for class next week, the court creates a split. And they say some of these rights are okay, some of these rights are not okay. They start dividing them up. But of course, the exact same rationale in Meyer and Pierce was used in Lochner and Atkins. They were the same types of cases, right? Even Atkins was 23, Meyer was 23, Pierce was 25. They were decided in the same time period. So you have to remember at the time that economic and personal liberty were considered one and the same, but they were separated later down the road. Okay? All right. In our next class for Thursday, we begin talking about the New Deal. Now, wait a minute, Josh. Didn't we already do the New Deal with cases like NLRB versus Jones and Laughlin Steel and Wickard versus Filburn? Right? Didn't we already do these cases? Yes. We did the New Deal from the perspective of federal power, right? We did the New Deal from the perspective of federal power, right? What are Congress's authorities to regulate local activity? Now we return to the New Deal with respect to the Due Process Clause, right? What happens when state laws run afoul of the liberty protected by the Due Process Clause, right? What you need to know is that after the 1920s, starting in the 1930s, the court began to shift to the left and became more deferential to state legislation and no longer want to scrutinize whether these laws ran afoul, right? In other words, the Harlan dissent in Lochner, remember Justice Harlan's dissent, which said we need to be more deferential, became the dominant position, right? During the New Deal, Harlan's position prevailed from Lochner. But ultimately, we'll see, following the New Deal in the 1950s, Holmes prevailed, right? When we study tomorrow United States against Caroline Products, Harlan is in charge. But the second case, Williamson versus Lee Optical, Holmes won out. So that's why we can't dunk on Holmes too much. He eventually got what he needed after he died. Okay, questions? All right, I'll see you all on Thursday. Thank you so much.